In 1968, after a good 20-something years at the bar, you took silk, and you took silk the first time you applied, which is pretty good.
Well, I was fortunate. Must have had some good friends.
Who was the Attorney General then?
That was Ken McCaw.
Oh, right. Yes, yes. So, but you actually only were silk for 2 years and then you became a judge in 1970.
That's right, yes.
Yes. Was there, a lot of people stay as silk for a long, long time, and a few I've interviewed have said they weren't temperamentally suited to be judges even when they were approached to become a judge. What about you? When you had the tap on the shoulder, if you like, to become a judge, did you just think, I'd like to move into becoming a judge?
Well, I didn't have any hesitation accepting the offer. I thought I had perhaps a few years of training, which might have helped, and never really gave any serious thought to it. I've been in the profession, I suppose, then, for 20-odd years, 30, almost 30 years or so, not quite, from 46 practice anyway. But I'd had the experience of being with us as an associate for a few years, which was immeasurably helpful. And I was, I think about 51 or something at the time. It's about time to move somewhere, if you're going to move at all.
Yes, but many do choose to stay silk for a long time and never entertain the prospect of becoming a judge. And there are those I've interviewed who said they just simply didn't have the right temperament to be a judge.
Yes.
Those doubts and questions.
That's a matter of personal choice. Some do it for can't afford it for economic reasons.
Yes.
And some probably see their future more in the law for the next 20 years or whatever it may be, than hearing cases, and perhaps they regard it as boring sometimes to have to listen to interminable evidence from dreary counsel or witnesses and dreary submissions.
Well, I suppose that we could put it another way. You by then knew a great deal about your fellow counsel, so
I did.
You were in quite a good position to know whether to look forward to, I suppose, a matter or not.
You can't always choose your counsel, but at least you can look. If you're trying to give people a fair hearing and a fair trial, well, you can't go very wrong, I think. And I hope I've succeeded in giving some calm to the courtroom rather than boisterous conduct. And
Yes, you presided over both civil and criminal trials in the 70s and the 80s, and I'd be interested to know in your opinion about the contrast between presiding over the cases in those days and what it's like today with present-day trials.
I'm a little out of touch, of course, with current-day trials, but except what I hear and read, and talk to fellow members of the profession. But trials, civil trials, were fairly short. They might vary between a day and a half to perhaps 4 or 5 days. The very long one would be 2 weeks. They mostly something very involved, like malicious prosecution or some other special medical case. And criminal trials could finish in 2 to 3 days. It was a long case went 5 days, and in 1971, when I did a poisoning case in Bathurst, that took 2 weeks. That was looked upon as an extremely long case. And now they go for months and months.
Would you put that down to the excessive amounts of paperwork that judges are now expected to go through?
I not necessarily, but the judge's task is not made any easier by the magnitude of the paper that's put to them. And I found that so when they abolished civil juries, I found that would be given a heap of medical reports from numerous doctors, all headed up by consent, but they had to be read very carefully, and that type of time-consuming, particularly if you got no submission from either side about them, in case there was something sort of a hidden bomb amongst the evidence.
Yes, that is interesting. You mentioned that. It's Well, among other things, security issues for judges have become a lot more pronounced. Or there was a period, certainly in the late 70s, early 80s, when judges' lives were in fact in danger.
Oh yes, did we know? And unfortunately and sadly, family court judges were blown up and shot dead, and two or three of them here in New South Wales. Mrs. Watson, Judge Watson's wife, and I think it was Justice Opie. He was Opie from Family Court, Opitz rather, and Chris G. I think he was firebombed or something happened to his house. So it's a very dangerous jurisdiction to be in.
Of course,
But,
that wasn't yours, though, but did you ever feel any concerns about your own security?
Oh, well, I did, up to a point, yes. I think, getting back to criminal trials, I think some of the criminal trials, particularly drug trials, they went for 2 and 3 weeks because of the question of surveillance evidence there and tracking every step that was taken in relation to the drugs, and then forensic expert evidence is also intensified and also in dispute sometimes. That lengthens the trial as well.
Yes.
But
that's also come
the
along.
only time,
Yeah, sorry, I was just going to say that's also come along with advances in technology, though, hasn't it?
yes, absolutely, yes, with all the DNA tests.
So perhaps it
and
would
so.
have happened anyway that trials would become prolonged in part because of advances in technology.
Yes, that would certainly could be correct. I found that in the drug trials were the ones where you most likely had need to have some concern. I always felt that I was, not always, felt in some cases I was followed from home, one case in particular. And then jurors were followed home, and one juror disappeared in one trial I had in a drug trial. And so there's always that danger.
One thing that's certainly emerged today is there is a great deal more questioning about judges' decisions than there used to be. Do you find that?
I think that is so. I think she's got more media attention now. The public are almost encouraged to become a source of criticism of the judiciary, sadly, without even knowing all the facts of cases. Expert commentators express their views and I think excite the attention of the general public on some issues. Very emotive issues, some of them.
Is that the main contrast, do you think, between today's perceptions of the courts and judges compared with, say, the 1950s?
I think so. Courts were treated in a different way in the 50s and 60s. Judges led very quiet lives. They didn't participate in conferences or exposition of particular doctrines on radio or television. They were, with other words, withdrawn in a sense from society, which made them appear as though they're living in ivory towers.
Do you think then the fact that they are more involved, or at least more visible, has that been a good thing, or not necessarily in your view? At least in terms of public life, of the role of the judge, because it certainly has changed. As you say, they were very removed in the past, and in some respects that was necessary to carry out their jobs properly.
Yes. Oh, I think that the changes have been somewhat for the good. I mean, particularly judges' participation in legal conferences and discussions of legal issues. But on the other hand, sometimes I get the impression because you are a judge, your words are expected to have more power. And I think sometimes people seize upon judges' expressions to bolster their case.
Yes, but as you say, not always wisely. There used to be a great deal more written up in papers, law reports and the like. Do you think that played a role in educating the public a bit better about why judges arrived at particular decisions? It
did. You know, there was a time when, particularly the Sydney Morning Herald used to run a page on different trials, and they'd follow each day a little summary of the evidence and so on. But that's all disappeared. I think that helped the public to some extent to understand. And I think strangely enough, more people attended trials in those days. I mean, members of the public. It's not unusual to find the courts at Darling House quite full well, not that the area was spacious, but nevertheless quite full of people attending a case and following it through.
So perhaps to an extent then governments can take the blame for a lot of this. You said before their role in abolishing jury trials. Maybe this is one, I suppose, an unintended consequence now, that because people attend trials much less, they don't really follow what's going on from
No,
moment to
they
moment.
don't really, and the sad part of it is that they're handing it over to the judges alone, and not the juries are not there to be at least represent the community in that sense, a broad sense.
Yes. What else do you feel is, if you like, problematic in the way a judge is supposed to operate today compared to the times when you were working in that role?
Well, of course, as I said, judges had a very little public life in the 50s and 60s, unless they happened to be holders of another office like the Lieutenant Governor or something like that. It probably changed a little in the 1950s, or even earlier, when Sir Leslie Heron was a judge. He was appointed in 1941, I think, but he'd been there for 30-odd years as a judge and Chief Justice. But he was one of the most outgoing judges that I've ever experienced. He was head of the Athletic Association. He was, I think, president of the Bowlers Club, Bowlers people. He was chairman of the Sydney Cricket Ground Trust. He was chairman of the Australian Rugby Union. He was really head of these numerous numbers of sporting bodies. And I think he did a lot in a way for the judiciary to integrate with the public by good example. And he was very popular.
But that wasn't necessarily your own style or own approach.
No, I took the more conservative view. I think that a little more reserved life probably moulded a little on Sir Frederick Jordan and the judges of his era.